All right, we are done. Yep. Okay, I'll call this meeting to order. Ms. Bonnie, will you call roll?
Yes. Trustee Knapp.
Thank you.
Here. Trustee Ringel.
Here.
And Trustee Faust.
Here. We have the Pledge of Allegiance. Of the United States. Indivisible. We just wanted to thank everybody for coming out tonight. We really appreciate having a crowd here. And thanks for your patience with the lack of seating, but it should be a good meeting. First of all, we're going to open the hearing. We're here for zoning application RCOD 23-02, Lewis Center Self-Storage. First, we're going to have a mass swearing in. So anybody who plans to speak tonight, please raise your right hand and our court reporter will swear you in. Any members of the audience as well that plan to give public testimony?
I do.
Okay, and when you later when we do have public comment, please give your name, address, and mention that you were sworn in or not. And if you have not been sworn in, we can swear you in at that point. First up, we'll have the staff report. Mr. Duffy.
Good evening. We are here to discuss case RCOD 23-02. The applicant is Rocky Point Partners, LLC, for two parcels at the corner of Gooding Boulevard and Corduroy Road, the total acreage being 8.770 acres. They are currently zoned planned commercial and office district. The request is to apply the Route 23 corridor overlay district to the parcels in question. The applicant is requesting to apply the RCOD to that acreage to allow for the construction and operation of a storage facility. The property again is currently zoned planned commercial and office district under rezoning case 10747, which was approved in 2001. The property is currently vacant. The property is surrounded to the north by planned commercial and multifamily planned residential, to the south by single family planned residential, to the east planned commercial, and to the west single family planned residential. On the following page there, you can see the development plan provided by the applicant. In terms of the development plan and standards, so this is the following is a brief summary of the applicant's request. Staff did receive updated materials at 11:40 a.m. this morning on May 22nd. We did update the staff report to include review of those updated materials. The applicant is proposing to construct one 3-story building, approximately 75,000 square feet, and 1 to 5 single-story buildings, of which the square footages vary, which would be comprised of storage as well as office space. The building to lot width ratio is listed as 40.3% for the Gooding Boulevard frontage and 56% for the Corduroy Road frontage. They both fall within the RCOD requirements of 40% to 70% building to lot width ratio. The building setbacks for the property vary depending on the property line in question, but include 100-foot building setbacks from any single family area, 15-foot building setbacks from side property lines that abut non-residential districts, and 25-foot setbacks from rear property lines that abut non-residential districts. The minimum building setback from local roads, of which both Gooding Boulevard and Corduroy Road are local roads, is 30 feet, and the maximum building setback from local roads is 40 feet. The applicant has proposed canopies between the single-story storage and office buildings in order to have them be considered as one building. If the canopies did not unify the structures, 3 of the single-story storage buildings would violate the maximum setback from Corduroy Road. All other setback requirements are met. All proposed buildings do comply with the maximum height permitted in the RCOD, which is 50 feet. Buildings A and B have exterior building materials largely composed of fiber cement, which is a permitted building material per our overlay standards. And a 5-foot sidewalk is proposed to be constructed along Corduroy Road in accordance with the RCOD requirements. For open space and landscaping, total open space provided is approximately 4.182 acres, roughly 0.7% of the site, which does meet the open space requirements. The street tree requirement in section 20.09BI1 is met along Corduroy Road and Gooding Boulevard frontages, except for the areas under the power line easement where trees cannot be planted. Although previous submittals had indicated that a decorative picket fence would be included, the applicant has indicated via email today that there is only one screening fence that is a maximum of 6 feet in height. A privacy fence is only permitted when providing required screening and cannot exceed those 6 feet in height, so the height does comply. The fencing locations are depicted on the architectural site plan provided by the applicant today. In terms of parking, the proposed site plan shows a total of 8 parking spaces and 4 loading spaces. Dimensions for parking and loading spaces are not shown on the site plan, although they appear to conform to the RCOD requirements. Because self-storage is not listed as a called-out use in Table 2A of the RCOD, there are no parking calculations to compare against. For lighting, the applicant did provide a new lighting plan today, May 22nd, while the lighting plan provided by the applicant now extends to all property lines as requested by staff, as shown on pages 8 and 9 of the luminaire summary and lighting plan sheets. The foot candle levels on the drawing are not shown properly, appearing as question mark symbols instead of indicating the point-by-point foot candle levels, which we would need to see. The fixtures indicated on the lighting plan submitted today show that they are 11 343 80-watt TWP wall pack lights that have a lumen level of 9950 lumens per section 20.09 F6. The light bulb utilized for all uses shall not produce more than 3,000 lumens. Therefore, a divergence would be required in order to use the light fixtures provided by the applicant in the package today. For signage, per an email from the applicant today, May 22nd, the 2 wall-mounted signs have been removed from earlier renditions of the building elevations and are no longer part of the application. I would just like to mention that if there are no wall signs being shown on the buildings, then no wall signs would be permitted on the buildings if they are not included in an approved development plan. An exhibit for a monument sign is also included with the application, and the landscaping plan identifies it as being set back 20 feet from the right-of-way, which would meet requirements. There is also a requirement for a minimum of 50 square feet of landscaping surrounding the monument sign, which appears to be met. In terms of divergences from the RCOD requirements, a list of the divergences, along with their justification as required by RCOD standards, was provided by the applicant, which listed the following divergence, and that would be a divergence from section 20.09BI1 to allow for fewer street trees than required under the power line easement. We do support this divergence request, as the requirements of the easement cannot allow trees to be planted in that area, and any development that occurred on these parcels would have to follow the same restriction. However, we did identify one additional divergence, which were not listed by the applicant in their divergence listing. Again, that was from 20.09 F6 to allow for light bulbs that produce light at a greater lumen count than is allowed per code. Additionally, the following may require divergences, but staff is not able to make a final determination at this time. From section 20.09 D5, for the parking requirements for this use are not clear, again, since they are not listed as a use in Table 2A, which lays out the parking requirements by use. And then another divergence that may be required from section 20.04. Again, the lighting plan provided appeared to have some errors and does not show the foot candle levels extending along the entire property and 30 feet beyond all property lines. So therefore, I'd say if the board wishes to move forward with approval of this application following this public hearing, I would recommend that a condition of that approval be that the applicant resubmits lighting plans that comply with all provisions of Article 20. In terms of the Orange Township Comprehensive Land Use Plan, the 2018 Comprehensive Plan mentions that these parcels are located within Subarea 8, Olentangy Valley Central, and the future land use map shows it as planned commercial. The subarea does not mention this parcel specifically in their bullet points, but indicates that the preferred use for land on the east side of Gooding Boulevard is planned office use as transition to residential. No single-use big box retail, that would mean individual retail use exceeding 100,000 square foot of floor area is allowed in this sub-area. A copy of the relevant language from the comprehensive plan is listed below on the following page. So it's not language per se, it's actually the future land use map of the comprehensive land use plan. It's a little hard to see. It's over there by the number 8 on the left-hand side of the screen, but indicates that the red indicates that these parcels are indicated for commercial use. In terms of the use, per section 20.01 of the Orange Township zoning resolution, the Route 23 corridor overlay district was created to, among other things, provide an opportunity for an appropriate mix of uses, enable an extensive review of design characteristics to ensure that projects are properly integrated into surroundings and compatible with adjacent development, and assures compatibility between proposed land uses through appropriate development controls. The overlay creates several subareas that outline appropriate uses within those areas. The parcels in question are located within the commercial office sub-area of the Route 23 corridor overlay district. While staff did initially believe that this might be a permitted use in that district and did communicate this to the applicant, upon further review, staff is now of the opinion that this is not a permitted use within this sub-area. Per section 20.04D33, a request to approve a use that is not listed as a permitted use in the sub-area shall not be considered a divergence and shall follow the statutory rezoning process to determine if such use should be added to the sub-area text. Because storage and self-storage facilities, including the marine services and the storage of boats and recreation vehicles, is listed as an explicitly permitted use in the advanced manufacturing, logistics, and research and development sub-area of the RCOD, staff believes that a global interpretation of the RCOD classifies this as an industrial use, which would not be permitted to be established upon the parcels in question. In terms of the current zoning, the parcels are currently zoned planned commercial, which under section 14.03 lists public storage unit facilities, also known as mini warehouses, as prohibited uses. The parcels are also subject to rezoning 10747. The development plan for this rezoning specifically lists storage or self-storage as a prohibited use. An excerpt of the prohibition included in the development plan is below on the following page. So you can see permitted uses for those parcels within these areas shall be as permitted in section 14.03 of the Orange Township zoning resolution. The following shall be excluded from all sections of this application. You can see there at the bottom of that bulleted list is storage or self-storage for rent to the public. While the uses of the underlying plan district would not apply, should a Route 23 corridor overlay application be approved for these parcels, the fact that storage or self-storage for rent to the public is prohibited for these parcels indicates that the Orange Township zoning resolution does not identify self-storage or mini warehousing as a commercial use, nor was it ever intended as a permitted use for these parcels. In terms of technical review, the Orange Township Fire Department has reviewed and conditionally approved the site plan. For the Delaware County Regional Planning Commission, as an overlay application, the full Regional Planning Commission did not vote to make a recommendation on this application. However, Regional Planning staff had the following comments. I'm not going to read the entire comments from the Regional Planning Commission, but I will jump down to the bullet point below. The site is located between new homes in the Grand Point subdivision to the south, condominiums in the village at North Falls to the west, commercial office uses to the south, and the Inn at Olentangy facility to the east. This proposal would place a warehousing use in the middle of a residential and low-impact commercial area. More critically, the site is located in the commercial office sub-area of the RCOD overlay, which does not allow for industrial uses. The proposed use is self-storage, which is classified as NAICS code 531130 and considered an industrial use. The RCOD allows for warehousing in the advanced manufacturing, logistics, and R&D district, and the Orange Township zoning resolution allows for this use in the industrial and planned industrial districts. Staff notes that there is a substantial amount of land in the RCOD that is included in the advanced manufacturing, logistics, and R&D district that allows for this use and may be more appropriate for this type of use. Therefore, RPC staff recommends denial to the Zoning Commission. In terms of the NAICS code, the 2022 NAICS code 533130 defines mini warehouses and self-storage units as an industry comprising of, quote, establishments primarily engaged in renting or leasing space for self-storage. These establishments provide secure space, i.e. rooms, compartments, lockers, containers, or outdoor space where clients can store and retrieve their goods. The Orange Township Zoning Commission held a work session on this application on December 20, 2023. We did send following comments to the applicant in writing following that meeting. I will not read that whole list. In general, I believe those comments have been addressed by the applicant. That is all I have for now.
Thank you, Mr. Duffy. Okay, next, the order of this hearing, first of all, we'll have the applicant presentation, and then the trustees will have a few questions, and then we'll be having public comment. So go ahead, applicants, and approach the podium, please, and give your name and address. Or you can sit there, sorry, yeah, it's fine.
Members of the board, Chris Ingram, 52 East Gay Street, Columbus, Ohio. I'm with the Voorhees Law Firm and I'm an attorney. I'm joined with my partner, Joe Miller, also of the Voorhees Law Firm. We're here on behalf of the applicant, Rocky Point Partners, LLC, and the property owner, North Orange Development, LLC. We're joined for purposes of the record by Alex Marsh, the applicant's representative, senior architect, Christine Trevelis from Archall, planning expert, Gary Smith, owner of GT Planning and Design. Thank you for your attention to this matter. I just have one housekeeping thing before I begin. I just wanted to make sure for purposes of our record, yesterday we were provided with a staff report that's different than what was just presented to the board, and I just want to make sure that yesterday's staff report is included in the record along with the one that was presented today.
And that was done because of the resubmission, the new information, correct?
Correct.
Yes, that's okay.
So, and so for purposes of the record, we received staff's comments yesterday morning. We saw those and we worked through those and addressed each and every comment through the revised submission, and staff amended their report to address those revisions and clarifications. And so we just want to make sure that the record is complete and contains yesterday's report, our clarifications, as well as today's report.
Okay, well, Ms. Donna, would you like to, this is our legal counsel here, would you like to address anything?
So a couple of things. Obviously, I think that the staff report circulated yesterday in terms of administrative value has the same administrative value as the application that it was reviewed consistent with yesterday. I mean, at the end of the day, yesterday's staff report is not the staff report that was presented today, based on information that the applicant resubmitted. And so I don't know that it is valid for the record. I mean, I think that the comment can be noted and the applicant's welcome to submit it into the record, but at the end of the day, the staff report that was presented just a moment ago is the final staff report, and it needed to be updated based on additional materials that were received a few hours ago.
And I have a copy here of a clean copy of yesterday's staff report that I hereby submit into the record. And the reason why we disagree with council's representation is that there are new provisions specifically that reference code section 1403 that were not in the prior staff report.
And that's not due to the changes that you made to the
No, it's
application,
not.
Jay?
No, it's not. Those pertain to the use. That hasn't changed.
Okay, so how, do we mark this as an exhibit or?
fine.
Okay, would you like to give it to the court reporter to mark? What exhibit would that be? Is it A? 6. 6, okay.
Thank you, Madam Chairman. And for purposes of the record, we've distributed to members of the board a binder that includes the development plan and the page sheets for the site plan materials, along with tab 1, which contains the lighting plan that was submitted today, along with tabs 2 and 3, which are revised elevations and site plans. Tab 4 contains the affidavit of Gary Smith, and tab 5 contains an email correspondence between Robin Duffy and Alex Marsh.
I'll have to I'll have to control it. Sorry.
Thank you, Ms. Bonnie.
Yes.
So if I could turn to the next slide, please. As staff indicated, the subject property is comprised of 2 parcels located at the northwest corner of Gooding Boulevard and Corduroy Road. And it consists of approximately 8.77 acres of vacant and undeveloped land. It's probably kind of hard to see from your viewpoint here on the TV screen, but in your binders, you can see that there are enormous transmission lines that bisect this property. The other significant thing for this particular site is it's surrounded by nearby properties that consist of a wide range of uses. So you have a veterinary facility, a public library, a daycare, a dental office, an assisted living facility, along with both single and multifamily residences. Next slide, please. And we're here before this board this evening to present a high-quality self-storage development. And as staff pointed out, this is an application to pull down the RCOD overlay to the property. The development plan illustrates that there are 2 self-storage buildings, a building A and a building B. This development was designed such that nearly half of the site will be preserved as open space. More specifically, 47.7% of the site will remain open space. The design team specifically designed this site plan to satisfy the development standards set forth in the Route 23 Corridor Overlay District. Portions of your zoning resolution, including those development standards set forth in sections 20.06 and 20.09. And we submit that the plans before this board this evening do comply with those development standards. We heard for the first time that there may be issues with the light bulbs being perhaps too bright. We don't think that's an issue, but to the extent it is, we certainly can agree to staff's proposed condition and will satisfy those lighting issues to the extent they exist. And so given that, there's in our minds only one divergence that is necessary for the development of this property, and that is driven solely and only because of those existing transmission lines. There is a no-build zone that prevents us from planting street trees under or near those transmission lines, and so that's the only divergence that is necessary. And frankly, that divergence is going to be required really no matter what we could put on this site. Next slide, please. I know this board is very familiar with the legal concept that Ohio townships are creatures of statute. That means that the Ohio Revised Code dictates what this township and this board can restrict with respect to any land use regulations or restrictions. And as set forth in your zoning resolution in section 20.01, the Route 23 Corridor Overlay District was created through the procedure set forth in the Ohio Revised Code, specifically, and this is technical, and sorry for the legalese, but specifically for pursuant to Revised Code 519.021, capital C. And in your binders, in the hard copy of our PowerPoint, we've included a screenshot of that specific code provision. And in reviewing the text that we've highlighted to direct your attention to, members of the board, in this case, what this means for the board is that it is tasked with the administrative determination of whether this application and development plan complies with the development regulations set forth in Article 20 of your zoning resolution. Because we're here to pull down Article 20 that overlay to this property. Next slide, please. And I'd point out too, as we heard staff's detailed and thorough review of this development plan, everything that this application is being compared to and held to is set forth in Article 20. And here, the zoning resolution's criteria for approval for this particular application in section 20.04I of your zoning resolution is actually very straightforward. And this application and the development plan before you satisfies each of this criteria. First of all, the development plan is consistent with the overlay district's purpose. It preserves nearly half the site's open space. It's entirely compatible with the eclectic range of commercial and residential uses that surround the property, and will provide local residents with much needed storage options. Because the subject property is located within the commercial office subarea, the applicable development regulations are set forth in sections 20.06 and 20.09 of your zoning resolution. And as staff pointed out, those development standards are met. There are no concerns that this self-storage facility, there are no concerns with the provision of essential public facilities or services to this self-storage facility. It's easily accessible through existing township roadways and will not create any unreasonable traffic congestion. Consequently, this self-storage facility will only benefit the health, safety, and welfare of the community by, again, providing a self-storage service that has a significant unmet demand in this area.
Okay, guys, let's keep it civil here, please.
And at this time, we would ask Gary Smith.
Mr. Smith is an expert land planner. He has a sworn affidavit in the binder before you at Exhibit 4.
Thanks, Joe. Chris. So again, ladies and gentlemen of the board, my name is Gary Smith. I'm a land planner, landscape architect. I've been involved in planning and zoning for the last 31 years. I've worked both for townships as zoning inspector, also in private practice. I've worked for a number of the larger planning firms in Central Ohio before starting my own firm in 2011.
Gary, I'm so sorry to interrupt. Can you confirm your address and whether you've been sworn in?
Yes, I have been sworn in. My address is 720 East Broad Street, Columbus, Ohio, 43215.
Thank you so much.
Sure. The applicant and the applicant's team has asked me to participate in kind of reviewing the facts surrounding the application and to look purely at one thing, whether or not a self-storage use would be considered a permitted use under the RCOD of the township. And in doing so, I looked at a number of factors, reviewed the RCOD, reviewed the township's zoning code, reviewed the comprehensive plan, the NAICS code, a number of other things to kind of come to my conclusions. It is my opinion professionally that the applicant's self-storage unit is a permitted use under the RCOD. As Chris mentioned earlier, given the requirements outlined in the Ohio Revised Code, Section 519.021, the standards that the applicant is being judged by with the townships tonight is the standard of the RCOD. The fact that this storage use is not a permitted use in the planned commercial is not relevant to this application at all. The applicant is asking for a pull down of the RCOD for this property. So, and under the commercial and office sub area of the RCOD, Section 2006, the code broadly permits commercial and office establishments of any type. That is specifically straight from the code. That is what it says, unless prohibited in Section 20.05. Since Section 20.05 does not specifically prohibit self-storage facilities, it falls back to being permitted as a commercial establishment. Now, the term commercial or commercial establishment is not defined in your zoning resolution or under the RCOD. So under Section 4.01 of your zoning resolution, such undefined terms are to be given the precise meaning or significance as that which is normally attributed to such word, or the same as defined in the Webster's Dictionary. Consulting Webster's, and under the plain terms, the normal meaning of commercial is defined as occupied with or engaged in commerce, of or related to commerce, prepared, done, or acting with sole or chief emphasis on saleability, profit, or success, or able to yield or make a profit. In my professional opinion and experience, self-storage facilities meet this definition of commercial establishment because a self-storage facility is a business engaged in providing local residents a storage service in exchange for a profit. In regards to the comprehensive plan, as Chris pointed out, again, the requirements of 519.021 are very specific. It requires you to judge the application against the requirements of the ROCD. The ROCD makes no mention of the comprehensive plan, but even if it did, the comprehensive plan does not outline specific recommendations for this property. This property is located in Subarea 8, Olentangy Valley Central, and the plan provides general recommendations, and it provides recommendations for property that is to the north, that is within 1,000 feet of Home Road. We are not within 1,000 feet of Home Road. And it provides specific recommendations for properties to the west of Gooding Boulevard, but it is relatively silent on our site, so it makes no recommendation to the property. Lastly, in regards to some of the comments about self-storage being an industrial use. In the technical review section of the staff report, staff has restated a conclusion from an unnamed staff member from Delaware Regional Planning Commission that I believe mischaracterizes the applicant's self-storage use as an industrial use of the property. It should be noted that the full Regional Planning Commission did not vote to make a recommendation on this application. But the staff report states in part that the proposed use is classified in the NAICS under section 531130 and is thereby considered an industrial use of the property. Now, in my professional opinion, this is based on fundamental misunderstanding of the use and classification of self-storage facilities. The NAICS, for those of you in the audience, means the North American Industry Classification System itself, in its own preface, spells out the theory behind the classification of businesses into different sectors. It says the NAICS is unique among industry classifications in that it is constructed within a single conceptual framework. Economic units, businesses, that have similar processes are classified in the same industry or sector, and the lines drawn between industries demarcate, to the extent practicable, differences in those sectors and processes. In other words, the separation between sectors and subsectors highlights differences between categorized uses in the NAICS. This means that businesses classified in Sector 11, agriculture, are not the same and are significantly different than businesses classified in, say, Sector 21, mining and quarrying, and so on. So self-storage, the proposed use, as staff has noted, is classified in the NAICS as subsector 531130, lessors of mini warehouses and self-storage units, and is grouped in the same sector, 53, the overall sector, with real estate and rental and leasing, and not with more traditional industrial uses. Under the NAICS, self-storage units are grouped along lessors of residential buildings and dwellings, lessors of non-residential buildings, and offices of real estate agents and brokers, real estate property managers, and real estate appraisers. Industrial uses, however, are classified separately in Section 23 construction, Section 31 through 33 manufacturing, Section 42 wholesale trade, and Section 48 and 49 transportation and warehousing, which includes Section 4931 warehousing and storage as referenced elsewhere in your code. So you can see that the mini warehouses are classified by the NAICS completely differently than industrial uses. In contrast to industrial uses, self-storage facilities such as the applicant's proposed use are significantly quieter, they are less busy, they generate far less traffic, generate almost no semi-truck traffic, do not involve industrial processes or equipment or noise, or involve the processing of chemicals or raw materials or the stamping of parts or machinery. In government classification and in practice, self-storage facilities are much more commercial in nature than they are industrial in nature. And in my professional opinion, the applicant's proposed self-storage use, I would have to agree with staff's initial assumption that self-storage use is approved for the applicant's property under the RCOD commercial office subarea. Thank you.
As mentioned previously, I'm Joe Miller, 52 East Gay. I have been sworn in. Mr. Smith, thank you. Your affidavit is before the trustees as Exhibit 4. Are the facts and testimony set forth in that affidavit true and accurate? Yeah. We could turn to the next slide. Trustees, I've had the pleasure and privilege of appearing before you often over the last several years, and I know that this board and each of its members value constituent service greatly, value the input and thoughts of the township residents. However, you know as well or better than I that you have also taken an oath of office. That oath of office is to uphold Ohio law. And what may happen tonight if you act in accordance with Ohio law, you would be making the right decision, but perhaps not the popular decision. The law of Ohio as it relates to zoning is very clear, and that is that the zoning resolution must always be construed in favor of the property owner and in favor of private property rights. Specifically, the first quote up there is from a case involving Orange Township in which I was involved many years ago, where it was affirmed yet again by the Delaware County Court of Common Pleas. The Supreme Court of Ohio stated that zoning resolutions are construed in favor of the property owner. The Supreme Court also, in precedent cited below that, has found often and repeatedly that restrictions on the free use of property must be strictly construed, and the scope of any restrictions cannot be expanded. In other words, you can't look for ways to preclude this use. And in fact, if you think that the zoning is ambiguous, all ties go to the property owner. Any ambiguity must be resolved in favor of the free use of property. But I submit to you here, based on your own code, this is not ambiguous. Ohio law is clear. You've heard it cited several times already tonight. Ohio Revised Code 519021C says if you're going to create a planned unit development like this overlay district, those are the only standards that you can apply. Section 20. 14.03, which staff cited in its report of about an hour ago for the first time, has no application here. Instead, you look to Section 20, and it permits under 20.06 any commercial establishments of any type. I submit to you that is as broad as it gets. It may not be popular in this room tonight, but it absolutely includes self-storage. It is not an industrial use for all the reasons that Mr. Smith just explained. And in fact, you know in your own common sense, self-storage is open to and available to the public. It is a general commercial use marketed to the general public. It is permitted in this overlay district. And if we look at the next slide, I submit to you that before there was a crowded room here tonight, before this proposal was perhaps considered unpopular, your staff, Mr. Duffy, got it 100% correct. Mr. Marsh, my client, to my right, came to the township nearly a year ago, June 7, 2023, and was told, oh, you want to do self-storage? Just pull down the overlay district. It's absolutely a permitted use. If we look at the next slide, the email in this slide and the next slide is Exhibit 5 in the binder before you. Mr. Marsh was as plain-spoken and direct with Mr. Duffy as he could be, asking about this Gooding Boulevard parcel. Asking directly, I'm trying to confirm if self-storage is allowed there or needs to be in the below district. Can you please confirm? If we look at the next slide, please. Mr. Duffy was as unequivocal as he was correct. Self-storage is a permitted use in the commercial office subarea of the Route 23 corridor overlay district. You just need to pull down the overlay district and apply it in order to move forward. If we look at the next slide, this is a good application. This is a good use. I know it's not a popular use in this room tonight. Self-storage is often sought out by townships because it's not impactful, because it does not generate traffic, because it has next to no trips at peak hours versus other more intense uses. This parcel is extremely challenging for any development because of its shape, because of the transmission lines that bisect it, and this is a well thought out design that will largely be invisible to the surrounding communities. No doors, no garage doors, no units face the exterior of the property. Instead, it is completely self-contained, including vehicles on site. And so I commend to you, because this is such clearly a permitted use, and because your own staff concedes and agrees it otherwise meets the standards for pulling down the overlay district, an arbitrary denial of this application tonight does subject this township to liability under federal law, Ohio law, and the U.S. and Ohio constitutions. That is because if an arbitrary zoning decision is allowed to stand, that equates under federal law, under U.S. Code 42, Section 1983, to a deprivation of the right to due process. It also would result in an unlawful taking in violation of the Fifth Amendment. This is a challenging site. You're not going to see many developments that can go here. And if you deny this application, you have deprived it of its economic use. Finally, this township would absolutely be straying into liability for failure to provide equal protection under law. This board has approved many developments within the overlay districts of this township, and the only standards ever applied to each of those parcels were those that your staff previously a year ago said are the ones that should apply here, Section 20. You didn't pick and choose from other sections of the code to try to deny an application, and this application cannot be treated any differently. Just in Delaware County in the last few years, Genoa Township, Berkshire Township, Liberty Township, Kingston Township have found each of themselves sued successfully in federal court for arbitrary zoning decisions. Orange Township has steered clear of that. I urge you again tonight to do the right thing in accordance with your oath, in accordance with law, and approve this application to avoid the unnecessary liability for damages and attorney's fees that could result. I would also commend to you, or state for the record, Chairman Knapp and members of the Board of Trustees, we do object to generalized public comment this evening. Your own counsel, Ms. Donnan, would agree.
Let's keep it down, please.
Your own counsel, Ms. Donnan, would agree. This is a quasi-judicial hearing, a proceeding where you are adjudicating the rights of this applicant and this property owner. Under Ohio law, the only persons withstanding to participate in these hearings are your staff, yourselves, the owner and the applicant, and only those property owners immediately contiguous and adjacent to the site. We object to any and all.
Excuse me.
I'll repeat.
when you are all giving your public comment, and please give him the same courtesy.
I'll repeat because I doubt that I was shouted down just by owners contiguous and immediately adjacent to this site. That is not many parcels at all, and we object to any other persons participating this evening.
Is there any,
Well, let's get a
further-
response from our legal counsel.
yeah,
Good
okay,
afternoon.
please.
And one additional item, I know that, again, there's a lot of people in here, appreciate everyone. But another thing to keep in mind, we do have a court reporter. She can only hear one person at a time, so it's important to just speak one at a time. So I do not disagree with Mr. Miller's assumption in terms of who has the right to speak. However, there is one exception. Again, he said contiguous property owners. The other exception is, in terms of who has the ability to speak, is property owners who experience a unique harm from the application. I do not know how this board will be able to determine whether or not members of this public will have a unique harm unless they're provided the opportunity to speak. The other option is for the board to make that determination for each and every person, and realistically, I don't believe that's possible. And so our general advice is to permit people to speak. The risk is denying someone who does have a unique harm from having the opportunity to provide testimony. Again, we've reminded, but those are the standards. So I don't disagree with Mr. Miller's list, but there is one additional qualification, and that is the unique harm.
Thank you. Is there any further information?
Not at this time, thank you. We're open to answering any questions you may have.
Okay. Did the other trustees have any questions?
I have a question.
Go ahead.
So I'd like to talk about the lighting report. So we've talked about it a couple of times this evening, but section 20.04, Roman numeral 33, and it's talking about the divergences. It states that the applicant may request a divergence from the development standards set forth in Article 20. An applicant making such a request shall specifically and separately list each requested divergence and the justification therefore on the development plan submittals, with a request that the proposed divergence be approved as part of and as shown on the development plan. So, and please correct me if I'm wrong on this timeline, Director Duffy, but I believe there was a work session with the Zoning Commission on December 20th, 2023, and out of that work session, there was a request for a revised lighting plan. And then the staff report that was provided yesterday also highlighted some potential divergences due to some seemingly missing information in the application with respect to lighting. And although the staff's recommendation has changed as to the potential divergences that might need to be requested and justified with respect to lighting in today's report, there are still questions, it seems, about whether or not the application has sufficient information with respect to lighting in order to have a justification for the potential divergence that might be needed. So my question is, sorry for the long preface, but is there any comment that you would like to make about the lighting report that's been submitted?
Thank you, Mr. Ringel. It was our understanding that all of the lighting issues were resolved based on the staff report that we received yesterday. And so to the extent there are this other issue regarding the lumen count, we have no problem whatsoever complying with that requirement. And we would agree to staff's proposed condition that any approval, the applicant resubmits lighting plans that comply with all provisions of Article 20. That's not a problem.
Okay, thank you.
Any other questions? Okay. I just have a few questions. So the property is currently owned by the North Orange development, is that correct?
Yes.
Okay, and who actually owns that company?
This is Alex Marsh at 10 North High Street. I was already sworn in, but that'd be the Robert Weiler family owns the land.
Okay. And All right. Is it correct then that Mr. Skip Weiler is a principal in the Rocky Point?
He's not a principal in Rocky Point. It's a joint venture between the landowner and Rocky Point.
Okay, so who owns Rocky Point? Is it you?
I do, and my partner.
Just you two, okay. So this is a joint venture between the existing property owner?
Correct.
And a new property, or, so when this property was rezoned back, what was it, 2000, I think 2006?
2001.
2001, okay, it was a while ago. So when it was originally zoned, it was to be planned commercial, and everybody knew that when it was purchased. Everyone knew that when it was subdivided out. And I see that you've had an issue trying to sell this property because it's not a very viable piece of property. So I feel that regardless of everything you've said tonight, I feel that this use just doesn't belong in the community. And you always knew up until this point when this RCD came along that you would have to develop it commercially. So you simply are using the cloud to now develop it. You never had any intention of developing it as storage units until recently, correct?
Beginning of 2023, we decided to develop it as self-storage.
Okay, so it has,
And just to be clear, I think the Weiler family purchased it a few years ago.
did they? Like,
Correct,
do you
yeah.
know what year that was?
I don't have the exact year now.
Okay. Let's see here.
So we don't necessarily have that history you may have with the property in terms of knowing of its uses during the period of ownership. What we do know is the overlay district was created in 2022, allowing for this.
Yes. And you own how many other Rocky Ridge owns, has how many other
We have
facilities?
2 other self-storage facilities in Columbus.
And is there any in any other state?
Nope.
No, are they located in in residential areas with planned commercial areas?
Yeah, surrounding residential.
Are they in industrial district or planned commercial?
One was zoned under industrial and one was zoned under commercial.
Where's the commercial one located?
There's one in Groveport and one in Delaware, right south of
Which
downtown
one
Delaware.
is in the commercial? Which one's in the PCD
the
district?
Groveport.
Groveport, okay.
And what are its neighbors?
You've got some single family, I think, to the northwest. Then you've got some industrial to the east, and you've got some commercial to the south.
And what's the spacing between the storage unit and the residential to the northwest? Is
I
it
think they're.
right about
I think
it?
it's adjacent property. Yeah.
Is it single family?
Correct.
It is single family. Let's see here.
Yeah, and the one in Delaware, actually to the north, has residential homes to the north.
So what you're saying is just simply because this is not it's not a prohibited use, that you believe it is a permitted use. Is that correct?
We believe it's explicitly a permitted use, as any commercial establishments of any type are what are permitted under 20.06.
So you're saying that basically under that section, the entire overlay should be allowed to have industrial development?
It's not an industrial development. It's for commercial use by
But you think a
individuals.
self-storage unit could go there anywhere on the RCD under our what we have designated as being planned commercial?
In this sub area, correct.
Okay. So there's, like you said, there's no specific definition of commercial real estate, but when I first heard about the different interpretations, I did look it up. And typically, I know this is not an official definition, but everybody knows this. Commercial real estate typically involves the types of buildings that people know and use in daily life, such as offices and retail stores. Industrial real estate, on the other hand, typically involves properties where goods are made, stored, and or shipped. So that's just the common, that's what everyone thinks industrial is. I believe it's a different use, different type of use. I don't believe that it actually fits in this area. And I'm just curious, as to when you have so many residents that are against this, why would you want to locate your business here with so many people don't want to welcome you here?
Respectfully, Chairman Knapp, the code does not talk about commercial real estate. It talks about commercial establishments, which this is. And frankly, self-storage is exactly the kind of use that people know and use in their daily life for any number of reasons. For college kids returning home with their stuff, for people going through a family change, for people moving. It is absolutely a commercial use that services individuals. And as to the persons here in the room tonight. I respect their property rights. This owner and this applicant respects their property rights. We are merely asking that ours be respected under your code as well.
So basically if a property is not a residential property, it's a commercial property. Every single commercial use is a commercial use. There's no differentiation in your mind.
I'm referring to
between
20,
industrial.
I'm sorry if I misapprehend your question, Chairman Knapp. 20.06 allows for commercial establishments of any type, except those that are specifically prohibited in Section 20. Self-storage is not one of them.
Right, but we differ as to the opinion of what commercial is versus industrial.
We may very well, though I think the greater weight of the evidence is certainly in favor of a commercial establishment, and even if it's close, the close calls go to the property owner. As to your question about why would we want to establish a use that we may very well find out in this room is unpopular, we simply want to be treated in accordance with your code. And that goes back to what I said earlier, that I respect this board, but I ask that you make decisions under law and not simply what's popular.
Okay. All right, I'll open up the hearing now to public comment. Is there anyone that wishes to come forward and give public comment? And if you do, please, we're going to have original testimony from the first few, and then if you have a similar comment, if you could just say that you agree with the prior person and add any additional information to save time. And please give your name and address for the record.
And state that you've been sworn in.
Oh, yes. State whether you've been
My
sworn.
name's Lyle Zender III. I live at 6920 Star Hollow Lane, courtyards at Clear Creek. Is the mic not on?
It's kicking on the YouTube stream.
Is there, and people here?
Shall I repeat?
Yeah, could you
My
please?
name's Lyle Zahner III. I live at courtyards at Clear Creek, 6920 Star Hollow Lane. I'm a retired commercial collection lawyer from Pittsburgh, Pennsylvania. I also was a municipal solicitor. I also served as solicitor for the two largest municipalities in Allegheny County, which is city of Pittsburgh. I'm going to preface my remarks by saying I am from Pennsylvania, and I'm not that familiar with the way y'all do things in Ohio, but this is the first time in my experience at any kind of zoning adjustment board hearing or anything, I've heard counsel threaten the board with a lawsuit. So So either y'all do things differently out here than we do in Southwest Pennsylvania, or some council are taking a chance. I know that the good people that are here, the residents, are going to assert the various reasons they think the change should not be permitted, based upon devaluation or diminution of value of their property, nuisance, etc. I'm not going to make that argument because they're going to make it better than I could. I'm going to make an argument that it should be denied for the simple reason that this board is authorized to provide and protect the health, welfare, safety, and security of the residents of Orange Township, Ohio. Now, I have not heard one thing tonight as to the need for the construction of this facility. I have not heard anything from council or any of their witnesses as to the existing number of facilities within a certain radius, within 2, 3, 4, 5 miles of the existing facilities. Are any of those facilities available for rental? Because I know for a fact, because I checked over today, I thought before I had come over here tonight, there's Prestige facility out here on Orange Road here, down by 23. They have all kinds of facilities that are open. Now, last year, in 1923, nationally, in the United States, 4.7% of storage facilities filed for foreclosure or were foreclosed upon by their lenders. What that has done has created a problem for the municipalities in which these are located, because typically once a lender forecloses upon a property, the owners are gone, and it becomes the problem of the municipality and the lender. The problem with storage facilities traditionally has been, once they're foreclosed upon, they become a nuisance. They become an area subject to crime. They become an area subject to unlawful activity. And I've not heard one thing tonight from any of the people here representing the applicant saying there is a need for this facility. In fact, we know for a fact it's going to be successful. It's going to be a financial success because there is an outstanding need in Orange Township for storage facilities. I did a little research myself before I came here. There are many, within a 5-mile radius, there are many, many storage facilities, all of which have availability tonight for rental. So, since council has chosen not to provide to us any type of financial information as to, one, the need, two, the availability to them of the financing of this, unless the owners plan on writing a check, I think to protect all of the residents of Orange Township from something that could be a real disaster, with Orange having to seize the property for taxes, or the lender having to seize it for failure to make appropriate payments, and then it becomes a burden on Orange Township, and then it becomes a burden on the citizens of Orange Township. I think the application should be denied. I don't think it has been shown by council or by the landowners that there is a need for this facility, that it's going to be a financial success, and would not be a burden upon the citizens of Orange Township.
Mr. Zinger, Mr. Zinger.
Is there anybody else who wishes to speak?
Mr. Zinger, before you get too far to your seat, would you mind coming back to the? Oh, sorry. Mr. Zinger, can you please confirm so it's on the record whether you've been sworn in?
I was.
Thank you. That's all. Thank you.
Thank you.
Good evening. My name is Kara Wireman, and I live at 232 Waterside Drive.
Can you confirm if you've been sworn in?
I have.
Thank you so much.
Thank you. I have one comment and one question. My first comment is, it's my understanding that Prestige Storage attempted to buy this parcel of property before they built across from the firehouse on 23. Now, they've just recently expanded, and they were denied by this committee the right to build a storage facility on that parcel of land. So my comment is, I don't know what would be different from 2 years ago versus now, and if we have any understanding of why they were denied and you feel that you should be approved now. So that's my first comment. My question is there any personal relationships between the owner of the property, the architectural firm, the expert witness, the developer, anybody on the board, or the zoning committee? Is there any personal connections between any of you, conflict of interest, to try to push this through?
So I can chime in. Can't speak to the applicant, and my name's Julie Don, and I'm legal counsel for the Board of Trustees. Obviously can't speak to the applicant in terms of their situation. They're not subject to Ohio's conflict of interest laws. What I can tell you is the Board of Trustees, the Zoning Commission, and Township staff are subject to Ohio ethics laws, and they are required to recuse themselves if they do have a conflict of interest. If this application were to impact themselves, their property, their family members, or their business associates, they would be required to recuse themselves. And so that by virtue of the three trustees sitting here tonight and the township staff who's sitting here, I am not I don't have those same obligations, but I am not affiliated with anyone on the other side of the table. But correct, by virtue of all of us, everyone being here today, there are no pending conflict of interest.
So there is no one that is associated with the architectural development firm and no personal connections to any employee of Orange Township or elected official in Orange Township.
To my knowledge, there are no conflict of interest that Ohio law would require the board members or the staff to recuse themselves.
Okay, that's all I have. Thank you.
You're welcome.
And Mr. Duffy, was it in fact denied for self-storage?
I am not sure, Ms. Mann.
I'm sorry, what?
I am not sure.
Okay, by this, yeah, I don't recall anyone else coming through for that kind of application for this. Maybe it was an informal.
It was prior to the overlay district.
Okay, so I think under the original existing zoning is probably how that would have been not denied, but maybe they came into the office and they said that that use would not fit here. So I'm not sure if it was officially denied, but that is a little bit different because it's the existing zoning on the property that absolutely does not allow for this industrial uses.
And our understanding is Prestige has not expressed interest nor pursued this property in the past.
Go ahead, sir. Come back to the podium, yeah.
I guess to my point is that I was told specifically by the owners of the Prestige storage unit that they did try to purchase that parcel. So maybe we could reach out to them and confirm that. But once again, I think it goes to point, they were denied because it wasn't a recommended light commercial type of building. It was an industrial type of building. So they did the proper thing. They went across the street to where it is zoned for industrial.
As your own, I'm sorry to interrupt, go ahead.
And so that's just my comment, is that, you know, they did the right thing. They went to where it's zoned properly for heavy industrial type of use. I can tell you that they are not happy that they would try to buy that property and then they were denied, and that they were going to look into it further. Is the only comment I was given by the owners.
And that was probably, I agree with the second half of that. I don't think it belongs here, but if under the existing, there's two different situations. Under the existing zoning, it's currently planned commercial and industrial uses are not allowed. We also have this overlay that you can pull down that changes the zoning. And that's what's under dispute now, not the existing zoning, if that makes sense.
I would like to commend Prestige for doing the right thing for its residents.
Thank you.
As
Okay, are
your
there
own
any-
representatives have just told you, there was no such application. And frankly, Prestige just opened phase 2 of their facility nearby, which speaks to why there may be vacancy. It's a brand new phase that just opened.
Okay, is there
There
anyone
was a
else?
market study performed.
So wishes to give public testimony?
Mike Armstrong, 6977 Falls View Circle. It's located adjacent to this property we're talking about.
Were you sworn in as well? Were you sworn in?
What's that?
Were you sworn in?
No. Okay. I was aware of the zoning for commercial office when I first bought my property. And I was okay with this, but not with a business zoned as industrial. There's no one here that would want to wake up every morning and see this outside their front door. This is a neighborhood of two very nice residential communities. To put something like this storage facility smack in between our two communities is a smack in the face of all of our residents. We do not want this facility in our neighborhood. This company knows that we do not want them here, but they don't care. They are not like State Farm. They will not be a good neighbor. They are not a good fit for our community. There are other places where this facility can properly locate. And I want to thank Mr. Duffy. I talked to him, emailed him a couple of times, been real good in providing me with information. And one thing is, from Mr. Duffy, the township's position that this is an industrial use, not a commercial use, and therefore not permitted in a sub-area of the overlay district in which these parcels are located. Then Mr. Duffy also answered a question for me that said, the property is currently zoned planned commercial. so it has its own development text or set of rules and approved uses. He attached the documents that I could review. And of note, he said, specifically, this storage unit is a prohibited use. So, with those two things alone, this should be enough reason to deny the proposed facility. A third thing I've got is a letter that I can give to you if you want it, from a realtor here. And it says, to whom it may concern, I am a local realtor with Howard Hanna Real Estate Services in Delaware. I own and operate the real estate office at 345 West Central Avenue, Delaware. I have had my real estate license for 24 years, have listed and sold over 3,000 residential properties in my career. I have been asked to provide my professional opinion as to how a commercial storage unit facility could affect the values of residential property surrounding them, specifically the North Falls condo community.
Madam Chairwoman and Council, we would object. This is hearsay. I can't cross-examine an email in this quasi-judicial hearing.
I think this
We would
is just
object to its
testimony.
reading and introduction to the record.
Ms. Donnan, is it correct? This is just testimony. Are we doing cross-exam?
What are you afraid of?
Okay, guys. Okay, listen, we all need to remain civil here, please. Yes?
Ms. Knapp, for purposes of, since this is an administrative hearing, the applicant is entitled to cross-examine.
I have chosen not to do so, but this email should not be permitted.
This is an email that you can have and you can verify yourselves before you make.
Can we just take it as?
So this is, the applicant has taken note of that, and so, and I think that's as much as you can do.
So we'll just take it for what it's worth.
Exactly. Yeah.
As she goes on, in my experience selling residential real estate for the past 24 years, homes and condos that are near or adjacent to commercial properties such as the proposed storage facility tends to sit on the market longer. They sell for less, and they can also be stigmatized by the neighboring commercial use. Currently, North Falls offers a secluded setting with quiet surroundings and is a highly sought-after community to live in. A storage facility near the complex could be considered an eyesore that distracts from that setting and negatively impacts the property values. The facility itself could scare potential buyers away and eliminate buyers' consideration by simply drive-by viewings. Through no fault of an innocent condo owner, their property value could truly suffer and the storage facility becomes their neighbor. I am happy to provide further professional opinion on this matter if necessary. Heather Kamen of Howard Hanna Real Estate Services. And with that alone, that should be another reason to deny the proposed facility. But to say that our zoning laws are ambiguous, no, they're not ambiguous. It says no self-storage facility permitted. They're the ones that are trying to make it ambiguous. And to put it like the other gentleman said, to put us, threaten us, which I consider a threat, with a lawsuit is something that we don't want that kind of a person, that kind of a neighbor, that kind of a company in our township. Thank you.
I'll be quick. I'm not sworn in.
Pardon me. I'm so sorry. I just want to provide a couple clarifying points. And just as a reminder, the board can only take sworn testimony with respect to the prior letter. Sworn testimony, and the applicant has to have the opportunity to cross-examine. So please consider that with respect to the information provided. Please, sir, go ahead.
So can we swear this gentleman in? Because I believe you said you weren't sworn in.
I must be sworn in?
You must be sworn in. Well, ideally.
Can I do it now? I do. David Rhodes, 302 Waterside Drive in Columbus, Delaware. I would like to say four things, if I may. First of all, I'm not a lawyer. I'm just a regular resident. I would agree with everything that's been said by everyone so far. I found it very interesting that the Regional Planning Commission recommended denial. I think that's strong information. And in my opinion, it just common sense says This should not be in a residential or near a residential area. End of message.
And any other one, people are coming up.
My name is Faria Shiro. I've not been sworn in. I swear by my religion, I'll tell the truth. Yeah.
All right.
So I have one question and I have a comment. And my name is Faria Shirwa, and I live at 246 Harness Way. The facility that is being proposed will be right at my backyard. And I thank everybody for coming out and supporting us because I was devastated. I think there is no room for sympathy because, you know, it took us 16 years to come up with a property that could be my dream house, you know. And now looking at a storage facility is just out of this world. Like, I'm really devastated with that news. My question is safety. I want to know, have you ever owned a storage facility?
The applicant has, and I've represented many other owners of storage facilities.
Business, but has he been a customer? Because I did have a storage facility on Morris Road, and I have things that I need to share so people can understand. You're running as a business, but have you owned one yourself? Have you stored anything?
Personally, yes, I have stored goods.
Okay. Was there any screening done?
Screening for the applicant?
For the applicant, was there any
There was
screening?
an application form we had to fill out.
And
Okay,
Mr. Marsh is kind to answer your questions,
Yeah,
but that's not why we're here.
Yes, we are here because the safety.
Ma'am, will you please address the board? Please address
Yeah,
the board.
so my question is the safety part of it. There is no screening done for the people who will be using the facility. So it's bringing crime, you know. There's a lot of cases. He talked about there will be no chemical. When I took the storage facility, nobody screened what I was doing with the property. You can hide a human being in there. You can bring any chemicals you want. So my question to them is, they are running this as a business, but not as, you know, customers themselves. So this poses safety. We are young families raising young children. And so now it's, you know, we are so afraid that our children cannot play at the backyard because we don't know if there's predators out there who are customers of this company, who are going to rent, legally allowed to be there, but they could be predators. And that is my concern as a young mother.
Madam Chair, if it's helpful. For what it's worth, if it's helpful information for this woman, for the public, obviously the lighting plan accounts for security measures. There is security fencing, a security gate. There are security cameras that are reviewed by on-site management.
Are there rules about what can be stored in the facility?
Yes. There are very standard rules that most storage facilities, certainly in the suburbs, adhere to.
But you have no
Premier
way.
is similar.
But you actually have no way of vetting what people are storing if you don't personally witness what they're bringing in and out.
Which, by the way, there is on-site management that does witness every in and out. Now, do we actively inspect each storage unit? No, and no storage company does that. But there are means by which this facility is secure.
Is it 24/7? Is it 24/7 the on-site management?
Well, it's not a 24/7 facility. It'll only be open really when sunlight's out.
Okay, good. All right. What hours are those? Just they vary.
Typically 8 a.m. to 7 p.m. is what we'll do.
Okay, so then it's not open for people cannot place items in overnight.
Correct. Yeah.
Okay.
Yeah.
Okay. All right. We'll have the next resident, please.
Good evening. I was sworn in earlier. My name is Matt Nichols. I live at 131 Corduroy Road, Delaware 43015. I am probably impacted more than most. I am one of the few properties that are directly adjacent to this proposed property. In fact, it's right across the street from my house. A couple things that I saw earlier today as you're going through your PowerPoint. You say that you're not going to build this no less than 30 feet, no more than 40 feet from Corduroy Road, but you're going to be more than 100 feet from residential property. Okay, not really sure how that works. I'd have to get out the measuring tape and roll it out there, but I'm pretty sure that 30 feet from the road is less than 100 feet from my property. Just going to throw that out there. Just want to put that in the record since we met the 100 feet mark. Also, I don't think anyone in this room is naive enough, applicant included, to think that this will not negatively impact property values in every single unit anywhere near this storage facility in this neighborhood.
If we can try to refrain from clapping sometimes because we need to be able to get through this hearing. I don't think any of us want to be here at midnight.
Everybody, I think some people would probably.
Okay.
Everybody in this room is here for a reason. Applicants talked about doing the right thing, maybe by law, maybe by not. Sometimes we just need to do the right thing. And I'm asking you, as someone who cares about this community, as someone who cares about my family and all the rest of the families here, I'm asking you, do the right thing. Thank you.
And I have one question.
Next, come on up.
So I have a question for the prior gentleman.
Oh, yeah, I'm sorry. Oh, yeah. I'm sorry, can we clarify real quick? Wait, you have a question for him?
Yes.
Yeah, and I have a question for you too. Go ahead. Or is that right?
Yes, sir.
And sir, for purposes of the record, you're not a licensed real estate appraiser, are you?
Hey, guys.
No, I am not.
Thank you.
I know. Remember, the hearing needs to proceed in a certain manner. He's allowed to ask, cross-examine any witnesses because of the nature of the hearing. So,
are you
yeah.
a licensed appraiser?
But he doesn't have, no, it's only one way, but thank you very much. Thank you.
That seems legit.
Now, regarding the 100 feet, do you wish to clarify that? Is it 100 feet from, is it from the actual homes or?
Just the property line?
Yeah, the property line.
Do we know how wide the road is? How wide corridor road is?
No more than 45 feet. I'm guessing. I'm estimating.
And then what's the
I'm not a certified measurement person either.
What's the distance from the corner of the property, I guess, to your property line? Yeah.
Based on what was shown earlier, was no more than 30 feet, no less than 40 feet, or somewhere between 30 and 40 from Corduroy Road, but more than 100 from
And Mr. Bells,
residential.
just so I'm clear, can you tell me what drawing you're looking at when you figure it out, please?
While our architect is looking, obviously, we're eyeballing not only the 30 feet, and not only the road, but the right of way as well on either side of the road, equating to 100 feet.
Okay.
And if you have any follow-up questions after you've given comment, give them to the board, and then there'll be an opportunity for us to ask additional questions after all public comment. So don't feel like you have to leave any questions unanswered.
Yeah, you can still come back up. All right, thank you.
Yeah, it looks like well more than 100 feet and an issue that staff has never raised, zoning commission.
So you're more than, would you clarify that? You're more than
What
100.
sheet are you looking at, sir?
I'm looking at 2 of 8 from our exhibit, from our development materials, which are in the front of the binder.
Two of 8 in the bottom.
The binder.
The binder.
Or tab 1.
It's not in.
I'm sorry, she needs to capture everything you guys say, so.
Are we, do you want to, I'm sorry, where is that information again? Where is that?
Or tap one.
I'm told the 100-foot setback is to use, but regardless,
Thank you so much.
if you scale that page 2 of 8, based on what's provided, it's 100 feet back from the right-of-way line. Again, while we may have spirited disagreement with staff on some things, this is something that has never been raised as an issue.
I do not at this time.
Where's the 100 feet mentioned?
Typically, in commercial property, it has to be 100 foot from residential.
In the, yes, in the,
Okay.
in the general standards of our zoning resolution.
And that would apply.
I don't.
Yeah, does it apply to the RCD, the 100 feet?
We'll look into that. If you want to continue with the public comment.
Okay. So we'll look into that comment. See if it applies, and we'll get back in a few minutes. Okay, next, would you like to come up and give public comment?
Hi, I'm Nikki Fryermood. I live at 7264 Falls View Circle, directly behind the proposed site, and this is my 10-year-old daughter, Sophia, and we've been sworn in. She asked to speak, and if you feel like you want to cross-examine her, I guess I could stay up here. But go ahead.
I moved here 2 years ago, and I love how I feel safe, and it's so pretty, and I hope you don't take that away.
Thank you.
Thank you.
Right, come on up.
My name is Jacob Dennehy. I have not been sworn in, so I'll go ahead and. I do. And my address is 480 Quarterway. My wife and I and my kids would be negatively impacted by this development. So just two quick questions. One is about the architect that was referenced here. Has anybody on the board referenced his qualifications?
Mr. Smith?
Gary Smith.
He did include an
affidavit
of his experience.
According to his website, he's a landscape architect for 23 years. So again, not sure how he's able to provide architectural design when he is just a landscape architect. And there was also a mention of other storage facilities owned by this landowner, but it was never actually provided to the public what those are. Please provide those so that we can actually cross-reference.
Sir, can you please address the board?
So we can please cross-reference the actual items that are other storage facilities that are owned by this provider.
Do you like to know the locations of the other?
Yes.
I think one's in Groveport.
Well, I want the name, because when they say they're close to a residential facility, close is relative term. Close, half mile, close, 50 feet. That information has not been provided, and it is completely opaque and is out of transparency that information should be provided.
Okay, do you have any other questions?
Nope, that's it. Thank you.
Thank you. And do they have the same name as this?
Different names. The one is located at 1100 London Road in Delaware. The other one is at 6435 Pontius Road in Groveport.
6435 Pontius?
Pontius Road.
Can you spell that, please?
Pontius.
Thank you.
So, I'm sorry, you said 110 London Road in Delaware?
Yeah. And Pontius Road is in what city?
Groveport.
Groveport, thank you.
It's, I think, technically Mifflin Township, but it's a Groveport area.
And there's none of these, you don't own any facilities in North Carolina?
No.
No. Okay. Okay, any more further comments from the public coming up?
Got a raise here.
Oh, I'm sorry.
Judy England, I was sworn in already. I live at 7339 Fallsview Circle, Delaware, Ohio, in Fallsview Circle. When I just heard the address, I wasn't going to speak, okay? But when I just heard that the address is London Road in Delaware, those facilities I'm familiar with, that is, sorry to say, a poor end of town. It's really not, at least in any way, up to the caliber of Orange Township that we live in. And comparing that area to having a storage facility and bringing it into Fallsview Circle area and North Orange is offensive to me. It would impact our neighborhoods, and no one in our community is excited about the storage facility at all. But London Road, I know that area, and that doesn't make me proud to think that we're going to be having a storage facility like that in our neighborhood. Thank you.
Elizabeth K. Landsberg, 7206 Fallsview Circle, Delaware, Ohio. I have been sworn in. My question to everyone in this room, have you lived by a storage facility?
No.
I wonder if the company who is presenting this to the board has had the experience of living by a storage facility and what impact that has had on their family, on their children, and the people in the community. Thank you.
Do you want to make? What was that? Okay.
Joel Hunt, 258 Waterside Drive, Village of North Falls, Delaware, Ohio. I have been sworn in. A couple of comments. One, I think that the reference to the amount of green area that will be in the proposed development is a little disingenuous, because most of that is directly under the power line and will be green space regardless of the development. Without that inclusion of green space, the density is much higher than it would otherwise be. And secondly, I think this is actually a bigger issue for me than my objection to the storage facility. And that is, I think that I would like to remind the board that what you do is very important to us. We appreciate your efforts, and I feel it's very, very important that we don't dilute your attempts to control the growth of Orange County. Thank you for what you do.
Thank you.
Thank you.
My name is Mark Knorr. I live at 7085 Fallsview Circle, and I have not been sworn in. I do. In 1986, I lived close to a storage facility. You can look it up. It was on Groves Road. There were 600 pounds of dynamite that were found there. You can pull up the article. They had to evacuate within a mile radius, and I had to tape up my windows. Now, they were able to burn it off with diesel fuel. This was off Groves Road and Hamilton Road. I don't want to go through that again. Thank you.
Any other testimony? Is there anyone else that would like to speak?
I've not been sworn in, so I will be sworn in. Yes. My name's Antoinette Mitchell. I live on 349 Morning Mist Court in the Epcot community. We see all these pictures of the 1-story. What's the 3-story that is supposed to be also built there, which will tower over everything in that area? We don't have anything that high. And there's supposed to be a 3-story building. And I want a clarification of that, because that will negatively impact the housing around there because it overlooks everything else. Nothing's that tall.
I believe that's the office. Is that correct? Is that the office?
But nothing
The
is that
office as well
tall.
as enclosed storage.
Okay.
It's
Is it closed storage also? Okay.
But, you know, that wasn't even addressed. We don't see these in these pretty pictures.
It's up on the screen. Michelle, can you do 4.01, please?
Obviously, there's no divergence for building height.
Right, it's within our
enclosed storage.
standards for height.
But it will be much higher than
Than the
everything in the
residential.
area, which will be very obnoxious.
Now, I will note that under the zoning that currently exists, they could have a 3-story building, even if it was planned commercial. So they could come in and build an office building that is 3 stories under the existing zoning, just for the record.
Okay, thank you.
And I would just point out, if it's a comfort to anyone, most of the homes surrounding in that area are 31 feet, and our building is 35 with a larger setback. 50 is allowable.
Yeah, 50 is
I have not been sworn in yet. I do. My name is Suzanne Kramer. I live at 178 Harness Way. First, thank you, Mr. Duffy, for answering 100 emails with questions from myself and our neighbors. Respectfully ask that you decline this request. While the gentlemen to my right are clearly experts in their field, experts in Ohio law, they are not the experts in our neighborhood. They are not the experts in Orange Township. You are. We are. I bought my home a year ago, last month. Drove right past this beautiful green space, which I realized upon buying my home it wouldn't be permanent. Oh, yes. I knew when buying our home, way above a reasonable price in this market, that something would go there eventually. I never, ever imagined it would be a storage facility. I'll answer the question in advance. No, I am not a licensed real estate professional. In banking and regulation, I don't know anything about that. What I do know is I would not have purchased this home a year ago if there were already a storage facility pre-existing. While I am not directly contiguous, as my neighbor is, I have a great view of your house, by the way, from my windows. We have a view of this property. It would obstruct the neighborhood. I would also argue it is not like other businesses in the area. We have a library, we have a daycare, we have a dentist office, we have a senior living facility. Those are not like businesses to a storage facility. I would also argue we don't need this space. If we do, it is accessible to us directly across 23, less than a mile from where we live. I think probably most of us would argue that that's not necessary. We're in new build neighborhoods with basements for the most part. We have plenty of storage of our own. I'm also curious, just, is there a precedence? I realize current zoning says this is not allowed. The question is to pull down that to make it allowable. Has this been done before? Is there precedence for this? Is this common? And especially in neighborhoods like ours with largely residential surroundings.
We haven't had very many applications. I think this is the first one that any of the three of us have actually held a hearing on, so.
Okay.
Yeah.
Those are my comments. Thank you.
All right, thanks. Anybody else? Is there anyone else that wishes to speak? We'll be closing public comments at when everyone's spoken, so if you want to speak, please come up now. Yeah, come on up.
Please restate your name.
Maria Shiro again, and I live 246 Harness Way. I just Googled the risk involved with the storage facilities, and it talks about the security risk are the most common and significant risk that the storage facilities face, theft and vandalization. And to mitigate these risks, storage facilities need to have robust security measures in place. So I was wondering what security measures were you planning if you put a storage facility there? And the other thing is, what will prevent these thefts to vandalize $1 million homes just adjacent to them?
Would you like to provide what kind of security measures will you have on site?
What I described before, obviously the lighting is all encompassing. There will be on-site management during the operations. There's a security gate, a coded security gate, and security fencing all around the facility, as well as extensive security cameras that are monitored.
So if someone is a renter in the facility, are they, and they obviously know the code to open the gate, are they unable to open it, say, at 8 p.m. after
Correct.
hours?
There's only hours at the gate.
Okay.
Right.
Okay.
And so, I renew my objection to public comment. We've obviously tried to be respectful. I guess I would only offer in summation and response that zoning approvals are not based upon popularity. They're not based upon market studies performed to the satisfaction of neighbors, though I would submit to you there is a market study that exists here, and the owners and applicant are prepared to make a $10 million investment in Orange Township. Zoning approvals are not based upon unfounded speculation regarding foreclosure, crime, property values, and impugning the clients who in Orange Township who happen to have a need for self-storage. There is a simple answer if this use is unpopular. It's to amend Section 20 of the zoning resolution. You can deal with this use, you can deal with building height if that's a concern to people, but this applicant has a vested right in the zoning as it currently exists, and I ask you to approve the application based upon that.
Okay, I'm going to close public comment. To the applicant, were you able to provide any testimony by any licensed realtors or other professionals as to the differences between commercial development and industrial development?
Have we brought testimony such as that from a realtor beyond a land planner for like Mr. Smith, who's done work for townships as well as for private developers? We have not brought a realtor in this evening on that question. Okay. I think instead it's an interpretation of your code.
Do the other trustees have questions?
Does anyone feel like there were any questions that were missed? Okay.
Okay. I do one more question. So, I'm sorry, what? Can we, okay, we'll just allow one more question. Is that fine?
Yeah, well,
right?
we can wrap up public comments after that.
Yeah.
You get to state your name, sorry.
That's actually on your prior question, Chairman Knapp. I apologize. Obviously, the Robert Weiler Company has been developing property, has appraisers, brokers on staff for decades and decades, and only makes marketable investments and developments within Central Ohio that they don't believe are impactful to the surrounding properties. Mr. Marsh is a licensed real estate broker and obviously believes that this development is beneficial as well as a commercial use.
Okay, but there's no independent testimony from a realtor or a broker regarding the difference between industrial and commercial?
On either side tonight, correct?
Yes. All right. Julie?
So it was brought up.
Can you give your name and address?
I'm sorry. My name's Julie Fisher. I live at 282 Harness Way.
And have you been
right
sworn?
Behind the.
Were you sworn in?
I have not.
Okay,
been.
she can swear in.
Yes, ma'am. It was brought up that the zoning specifically said no storage facilities. So I don't know if we all understand how that the zoning says that specifically. We all felt very safe because of that. And now you're coming to say that that's not the zoning. So I think we all want to hear an understanding of the duality.
Well, it's the existing zoning, the property was zoned years ago and it's planned commercial, and that zoning excludes things like this, like warehouses and storage units. So a few years ago, during a time I was not in office and I objected to it greatly, the overlay district was placed over 23, allowing people to pull down these types of zonings for their property. So they can pull down a separate type of zoning, which has different regulations.
What does that mean?
There's essentially an optional set of zoning rules that people can opt into, and that's what the applicant is
asking
submitting their application under. Is under these optional rules.
You guys to say yes.
It's up to the rules of the overlay Ohio law, and then it comes to the board for the decision as to whether or not to grant their application.
Yeah, but the applicant chooses that. So the advantage to them is it's a faster process, but unfortunately there's no right of referendum, which means that the residents cannot get together and file a petition to have it overturned, unfortunately, in this type of situation, which is why I objected to it. But it is in place currently, so we do have to go by the regulations if they choose to to pull those in and use those instead. But they'll also be placed into our JED, which means they'll be paying some income tax as part of that.
You're
If it
saying
were
that we
approved.
all will
If it
pay
was
income
approved, yes.
tax?
You
saying that we'll all-
the property? Yeah, property, yeah, and income tax and
So do you guys even have any ability to say no to this? Or are you saying that you don't actually have any legal?
Well, we don't really know right now.
So maybe I can chime in. So what Mr. Miller and Mr. Ingram have said is if, and one of the benefits of, well, maybe not benefits, but with respect to the administrative convenience of an overlay, if an application meets the requirements set forth in the overlay text, then the board must approve. And one of the issues or one of the questions is whether or not the use in question actually meets those criteria. And so that's what, again, that's what Robin outlined in his staff report. That's what Mr. Ingram and Mr. Miller kind of walked through.
So whether or not their applications
Meet those
complete is acceptable for us to be able to approve or deny.
Correct. Yeah, and that's different than a regular rezoning because we could deny it for additional reasons if we choose. But this is a different type of process, and it makes it much easier for the applicant to push a zoning through.
Because I guess it's confusing to all of us because all the guidance we have gotten thus far was that, no, this couldn't possibly go through. I too just purchased my home less than 2 years ago and never would have if I knew this was going to be happening. And our whole neighborhood is brand new. So this is a shock to all of us. So like, you might be pissed if you can't build there. We're going to be pissed if you can for the same exact reason. Why would you want to do this?
Now, just to be clear, they could, right now, under the current zoning, they could develop that, any applicant could develop that as a commercial use right now.
Yes, understood.
Right, you understand that? Okay.
Yeah,
So
yeah,
people have property rights and, but I.
You have a
it could be a
daycare,
50-foot tall building.
library, a daycare, a dog place, like all these like family-friendly establishments around us. Who would have guessed that someone would want to put a storage facility?
Unfortunately, the overlay is what they're arguing allows them to be able to do that. So we'll try to make a determination.
Well, I can tell you this. If there's anything we can do to help you find a reason to say no, I mean, I think we'll all help. Yeah, so.
Thank you. Thank you. Is there anybody else? Last call?
It looks like.
Are we done? Okay.
Looks like, yeah, we can wrap it
Okay,
up.
so I'll go ahead and close the public comment. So the applicant is arguing that commercial establishments, the plain meaning of commercial establishments are business engaged in commerce for a profit. Applicant's self-storage facility will be a business engaged in providing enclosed storage service to residents for financial gain. But I argue that the definition of commercial is concerned with or engaged in commerce. There's two different definitions from Oxford and Webster, but the activity of buying and selling, especially on a large scale. And I do not find that this is a commercial establishment. They're not engaging in commerce. So that's my opinion. Because the definition of commerce is interchange or the exchange or buying and selling of commodities on a large scale involving transportation from place to place, but it is buying and selling. Nothing is being bought or sold here. It's other than a service where you're storing things.
As well as moving products. So the record is clear. Moving products are sold on site. And you are correct. Storage services are provided for payment.
What percentage of your business would be the selling of those items?
A smaller percentage.
What percentage would you say?
10%.
You mean like boxes and tape?
We sell moving goods.
Like boxes and tape and anything else?
And boxes.
So 10% of your business will be boxes and tape?
Boxes, tape, rocks.
10%. Okay. Is that standard at your other
I just want
business?
the record to be clear. There is the sale of product taking place, but you are correct. There is also the sale of services for payment. Just as an oil change place is considered to be a commercial establishment, not industrial, because they provide a service for payment, this too is in that same regard.
But an oil change, is that a commercial use though? Do we consider an oil change commercial or?
Do we want a barber shop, a bank, private services for payment?
I think we're going to do that at the very end, though, right?
So I suppose, obviously, the board can have discussions. I guess I would ask if you have any questions for the applicant, or if the applicant has any final words. But if you're, other than that, if you're ready to kind of, you do have the ability to enter into private deliberations to have those discussions. One additional kind of housekeeping item on that end, because you do have a packed house. If the board thinks if there's any chance that you're not going to render a decision tonight, you may want to let the folks know the board's going to move into private deliberations, come out, close the hearing, but not render a decision tonight. Just so that way, again, a lot of people here.
And if that were the case, how would the residents here tonight hear of our decision?
So the board has to make a decision. Assuming the board closes the hearing tonight, the board has to render a decision within 30 days. Obviously, that's up to the board in terms of when that happens, if it's at one of your regular meetings or a special meeting. But you would go about communicating, through your website, your social media, that type of thing.
And at that time, if we were to do it in the future, what you said was within 30 days, it would not be a back and forth discussion or anything. It would literally be, this is the decision.
It would be a decision, correct.
Right.
So anybody could listen to our YouTube hearing, and then they could hear the decision.
Yeah, they could still come and watch it.
Or they could come, yes.
Yeah.
Everyone's always invited.
I differ that you're engaged in commerce. I think if 90% of your business, and I suspect, honestly, it's probably more like 95% of your business is storing items, I do not believe that falls within the definition of a commercial establishment, which is what you're arguing, and I have a difference of opinion on that. Storage, to me, is not engaging in commerce. So is there anything else that you would like to say?
Simply, I would move our exhibit as well as our presentation to the record, exhibits 1 through 6, as well as the development plan and materials, the staff report that we labeled at exhibit 6, and ask that those be considered part of the record this evening. I would also, in the category of, obviously we disagree. It sounds as though we disagree, Chairman Knapp, as to the sale of services as a commercial use. You can think of anything like that in your daily life, whether it's banking or going to the barber shop, where goods are not exchanged. But regardless, I would point out, as a commercial use, self-storage is not impactful. No traffic study is even required under your code because it is not an impactful use. It does not drive traffic. The traffic is internal to the site. It's much less intense than any number of commercial uses, including drive-throughs that could go on this site. So I offer that for what it's worth for the neighbors.
Yeah, we do not have, back when we were, decades ago, when we were doing the land use plan and the zoning resolution, we deliberately kept industrial districts away from residential. I don't believe any districts exist in the township where we have industrial right up next to our commercial.
And that is the nub of our disagreement this evening.
Right. Okay, is there anything else? Okay, I think we're going to go into deliberations.
I would urge you, for the applicant, for the owner, for the folks here tonight, I would urge you to come out of executive session and announce your decision this evening.
Okay, I do not.
We appreciate that offer.
Yeah. But we're not going to take
We'll deliberate on it. And then we'll likely render an opinion at a later date. That way we've had proper time to reflect on all of the information that's been provided tonight.
Yeah, we're going to need some time. So now explain to me, which are your exhibits? Is it, you said 1 through 6, which?
It's the entirety of the binder, which includes our presentation,
1 through 5,
which isn't labeled, and our development plan materials, as well as 1 through 6. 6 is what we labeled here tonight, the staff report of yesterday. I'm sorry, could I just finish that sentence? The staff report we labeled exhibit 6. Now, yes.
Okay, and this has been?
We're leaving a copy with the court report before the record.
Okay, so we have 6 exhibits, and then the staff report is 6.
If they've done, Can I just, I'm sorry, if I know folks are leaving, if you can try to keep voices to a minimum. We are still on record and trying to capture all of our communication here, so appreciate your time. Thank you.
So if they have used numbers, I would suggest identifying the final staff report as Exhibit A. And we can move that into the record as well.
Okay, so the staff report from today is labeled as Exhibit A. And do we need to give her a copy? Okay, and that's all the exhibits, is that correct?
Yeah, and if for clarity's sake, we will, with the court reporter, label our presentation as Exhibit 7 and our development plan materials, which should be part of the record because they've been with staff for some time, we'll label as Exhibit 8 for clarity's sake.
Okay, so is that fine to label those? Okay. So, where is that? Okay. So we are going to, so the board does not plan to issue a decision tonight. We have, it says written decisions will be made within 30 days. So we will come back out. We're going to go into private deliberations, and then we will not be making a decision tonight. And we will announce when that decision will be made when we come back out. So I make a motion to enter into private deliberations.
Second. Trustee Knapp?
Yes?
Trustee Faust?
Yes.
And Trustee Ringel?
Yes.
Thank you, everybody, for coming. I appreciate it.
Thank you so much for your time.
Go ahead.
All right, we are back on.
Okay. I make a motion to exit private deliberations.
Second?
Trustee Knapp?
Yes.
Trustee Ringel?
Yes.
Trustee Faust?
Yes.
Okay, we have 30 days to make our official written decision, and we anticipate that our decision will be made at our regular trustee meeting on Tuesday, June 18th at 3 p.m. So that is subject to change, but we will notify the public how through listserv or whatever way.
Yeah,
or
our
people can
social
call in.
media channels.
Yeah, we'll notify or will be available on request.
And Robin, assuming that it is the date that we are able to make the decision, are you able to email the listserv of families who have, just like, hey, the email that said, a whole bunch of people have responded, just like.
Yeah, whoever, the individuals that were on the sign-in sheet, we can notify them.
Okay, so we can do it that way. Yeah, so we are fairly certain we'll do it that day, but if it were to change, we'll notify the public in advance. Anything else? Okay, I make a motion to close the hearing.
Second?
Trustee Knapp?
Yes.
Trustee Faust?
Yes.
Trustee Ringel?
Yes.
Okay, I make a motion to adjourn this meeting.
Second?
Trustee Knapp?
Yes.
Trustee Ringel?
Yes.
Trustee Faust?
Yes.
Okay, meeting adjourned.
Thank
Thank
you.
you.